The next matter to come before the court is Deems versus EcoWater Systems. Now, we had this scheduled for 11 o'clock, and the appellant evidently is not going to be arguing. Do you know about that?
Yes, Your Honor.
Okay.
We found out.
So, I'm sorry.
We found out this morning.
Okay. So at any rate, you will have 15 minutes, and you can divide that as you please, that 15 minutes, and we're ready to listen.
Thank you, Your Honor. Your Honors, Colleen Mountcastle on behalf of App.No EcoWater. I'm going to take 7.5 minutes, possibly not even that length of time unless the court has questions for me, in order to allow the co-appellee to have sufficient time to argue as well. We're here today on a decision granting summary judgment in favor of the App.No EcoWater and Hempy. And this is an interesting case in the sense that the appellants, Ron and Rick Deems, are basically scorned potential purchasers who tried and failed to purchase a business, and instead of suing the person who allegedly breached the contract that was entered into between Rick Deems and Ronald Learn, they've instead sued the successful purchaser, Hempy Water Conditioning, and my client, a third-party manufacturer of water conditioning products. Ronald Learn and Hempy and Ronald Learn and Rick Deems were negotiating a purchase of Ronald Learn's company, Lindsay Water Company. It was done in an open and competitive market. There were two potential purchasers, and ultimately Hempy was the successful purchaser, and that was Ronald Learn's choice. He was the person who was selling his company, and the undisputed facts show he was never coerced, intimidated, or any wrongdoing on the part of EcoWater to affect that sale or to make sure that Rick Deems wasn't the successful purchaser. Ronald Learn unequivocally stated that in his testimony, that he was not coerced or intimidated. We're looking at two claims that I'd like to talk about: intentional interference with a contract and intentional interference with a business relationship. Both of them have very similar factors, but I think what's important with respect to the claim relative to the contract is a contract never existed here. And even if we leap ahead from that element, because the trial court said that there could be a potential question of fact relative to that issue as to whether a contract between Rick Deems and Ronald Learn existed, the second part is the alleged wrongdoer, that would be my client, EcoWater, had no knowledge of this alleged contract that existed. The only evidence that they have cited to is a conversation that took place between Rick Deems and Dean Roberts of EcoWater. At the time that Rick Deems called Mr. Roberts of EcoWater, he said, "I'm purchasing Lindsay soft water." That was what he said to Dean Roberts. He did not present a written purchase agreement. He did not present anything from Mr. Learn stating, "I'm going to be selling Lindsay soft water" to Mr. Deems. He simply made a call out of the blue and said to Dean Roberts, "I'm purchasing this company." So for that leap to be made to suggest that that is evidence of a contract, that Dean Roberts somehow knew that a contract existed simply because someone made a phone call out of the blue and said he was going to be purchasing a company, it just doesn't meet the standard of showing that EcoWater had any knowledge of this supposed contract. It's also important to point out that in appellant's briefing and in the arguments that they have made, they're suggesting that the contract was for a purchase price of $550,000. If you look at appellant's briefing itself, when it talks about the sequence of events, the phone call to Mr. Roberts actually took place prior to that $550,000 purchase price allegedly being agreed upon between Mr. Learns and Mr. Deems. So it really is a leap to suggest that at the time that Mr. Deems called Mr. Roberts, that EcoWater would be aware of any contract, because at the time of that phone call, certainly a contract did not exist, if it ever existed.
Do I understand your position to be that at the time that the conversation between Roberts and Deems took place, that the offer of $550,000 had not been made?
That's correct, Your Honor.
So they were still at the 400 and something?
That's right. I believe at that point, the $400,000 contract price may have been rejected already by Mr. Learn, but they certainly hadn't gotten to the handshake agreement point of that $550,000 amount. And again, that plays out simply if you look at the way the facts are stated by the appellant in this case. So it's not even just our position, it's actually, an undisputed fact that that's the sequence of events.
And even at that point, there was no discussion about whether the realty would be included in that?
That's right. That was a term that was still under negotiation between Mr. Deems and Mr. Learn. And there really was never a decision on the real estate term, whether or not it would be included in the sale. There was some evidence when ultimately that $550,000 price allegedly was agreed upon that that term had been resolved, but even then there's still a question with respect to that. But I guess with respect to both of these claims, the intentional interference claims, I'd like to talk about the justification element that's found in the interference with a contract claim and the reasonable business interest that creates a qualified privilege for a business. And that's something that's been discussed by this court in the Elite Designer Homes and Walter and Murphy decisions relative to a claim for intentional interference with a business relationship. The other thing that appellants are focusing on is Barb Polson of EcoWater's conversation with Mr. Learn. Barb Polson called Mr. Learn and said, if you have a purchaser for Lindsay, you have to have them submit an application. There is an allegation there that she made a reference to a lawsuit that the Deems had against EcoWater that was resolved back in 2002, and she in fact testified that she made reference to that. However, she also said, but we don't know, we need to resolve that once we see the application. And that is the sole allegation of interference that has been raised. I'd ask this court to look at Ms. Polson's testimony in that regard, and it's on page 86 of her deposition. If that is the sole interference that they're talking about, it's obvious from that testimony that all she's saying is, we need to see the application before we make a determination. She makes an offhand comment, but she still said, let's follow the procedure. And it's important to know.
Was there an issue of fact as to whether she said he can't be qualified?
There isn't an issue of fact, actually. She did say during that conversation that he couldn't be qualified, but the basis of that statement was because he hadn't submitted his application yet, and because he hadn't submitted anything in writing to indicate that this purchase was a done deal. And that's what Roberts told him he needed to do before they would send out the application. And in fact, Mr. Deems himself in his own testimony admits that what Ms. Polson said during that conversation was true, that he was not yet a qualified dealer of EcoWater.
But doesn't that require us to resolve some inferences in favor of your client, which we're not permitted to do under the summary judgment standard?
Your Honor, we're not looking at a question of fact, because in that instance, he was not a qualified dealer. That is something that is undisputed. Mr. Deems admitted that during his deposition testimony, that as of that conversation, when Ms. Polson is having that conversation with Mr. Learn, he is not a qualified dealer.
But that's my point.
Okay.
There's a difference between he is not yet qualified, or he has not submitted his application, there's a difference between that and he can't be qualified.
Right.
And what you're asking us to do, it seems to me, is to infer on behalf of your client that she is saying and intending to say the former and not the latter. He just can't be.
I understand the nuance that you're making, Your Honor. I will.
And I was just gonna tell you, and answer her question, but I don't know, you're running into a time problem, so. Go
Right,
ahead.
and just very briefly, there is no evidence that she said otherwise. Mr. Learn actually doesn't recall what she said whatsoever. That's in his testimony. So the conversation, again, is between Learn and Paulson. Mr. Learn said, I don't remember what she told me. And then what Ms. Paulson said was, he needs to submit an application, period. So there is no question of fact other than what has been argued. The testimony is as it is.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. Please the court, I'm John Hill, and I represent EcoWater, which, as you heard, was the successful buyer of this business. And from Hempy's perspective, the questions before the court essentially are, under what standard of liability will we permit a successful bidder in competition to be sued for tortious interference? We think that's what this case boils down to. In order to try to make that argument, what we believe is before the court is the appellant's stacking inference upon inference upon inference to try to round out and put flesh on what really is just a theory or a suspicion here. And we actually cited in our brief at pages 13 to 14 the law that you're not permitted when you're opposing summary judgment to construe the evidence in your favor and then make inferences from that construction and then make more inferences on top of that to try to fill in gaps in the evidence. And that's what we believe is happening here when the evidence is looked at versus the argument that's presented in the brief. I think that on the tortious interference claim, whether it's with contract or with business relations, my co-counsel made a very good point, and that is here the court has unequivocal testimony from the independent witness, not a party, Mr. Learn, saying, I wasn't induced by anything anyone else did. This decision to sell to Hempy was mine and mine alone. And that's strong evidence, and for the plaintiff, the appellant, to overcome it, they would be required to cite some evidence that a jury could grab onto and reasonably conclude exactly the opposite. And we don't believe that they've done that. Specific to Hempy, the claim of interference with contract, we agree with co-counsel that first and foremost, whether a contract was made here is a legal question, and we don't believe an enforceable contract existed here because there were too many elements that were undecided. But if we move beyond that, Hempy as well made the argument to the trial court that Hempy didn't know that there was a contract even if there was. And it's interesting that when the appellant tries to suggest otherwise, when the appellant tries to argue that Hempy knew there was a contract and interfered with it, if you look closely, what they really talk about is, well, you knew we were negotiating. And I'd submit that's not enough to make the claim of interference with contract. The element is you have to know there's a contract and then set about intending to induce someone to breach it. And the best that the appellant's been able to argue here is, well, you knew that we were negotiating and you were trying to match our offers. I would submit that's an admission. They didn't know that there was in fact a contract to interfere with.
How do you read the trial court's statement about whether a contract existed that was even though words to the effect that, well, there may be some issue with regard to enforceability.
Right. I think, I admit it's open to interpretation. I personally interpret it as the court was doing what we all do as lawyers and judges, kind of stepping around the issue and saying, that's an issue that maybe I can see a closer argument on, but I don't need to reach it because here's where the real weakness of the claim is. That's how I read it. I don't read it as a finding that there was a fact issue on this point or something to that effect. But admittedly, it's open to argument. Frankly, I suppose I should touch on the fraud claim because I think on appeal it's only Hempy that the fraud claim is pursued against. And it is based on, based on their brief, it's based on a single statement, the entire fraud claim. That being Mr. Nedler telling Mr. Deems, Rick Deems, that, Deems apparently brings up this so-called confidentiality agreement he had reached with Paul Staley allegedly years before. And Nedler supposedly saying, well, I respect that, but if you can't make a deal with Learn, then we would be interested to buy the company. That's the statement which is supposedly fraud on Deems. And what I'd submit to the court is, first of all, there's not any evidence that that's a false statement. More importantly, there has to be an intent to defraud, to make a claim for fraud. And I'd submit this suggests exactly the opposite. This is not Nedler saying, oh, I have no interest, we're never going to bid, go ahead, good luck. He's essentially, according to even Deems' version, saying, well, if you don't make a deal that I'm going to, there's nothing about that, any inference you could make or construction of it, I don't think you could construe that to be an intent to defraud Deems, instead of really telling them what the truth was.
And counsel, you're out of time.
Oh, thank you.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides. And you can also look on the Supreme Court website and our website. Thank you very much.
Thank you.